Why don't we go ahead and get started? Jennifer. Hello, folks. Why don't we go ahead and get started? We're 2 minutes after. Let's go ahead and call the meeting to order. Please turn off your cell phones. And it's a technology thing.
I know.
So all rise and let's say a prayer and pledge allegiance. So, Heavenly Father, as we gather today for this Planning Commission meeting, we humbly ask for your guidance and wisdom in our deliberations. Grant us the discernment to see the needs of the community clearly and the foresight to make decisions that promote responsible development while honoring the character of our county. May our discussions be respectful, thoughtful, and focused on the greater good. Help us to listen attentively to all perspectives, weigh options with fairness, and ultimately choose what is best for the future of our community. We thank you for your presence with us and ask that you bless our work today. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
I'm going to have to do that once.
Can we do a roll call?
Roll call. Excuse me. Ken Knudsen.
Here.
Diana Edstrom. Here. Dan McCallum.
Here.
Kyle DiNardo.
Here.
Nicole Hunt.
Here.
John Gresham.
Here.
Dee Dee Schott Grace. Dee Dee Schott Grace. Absent. Robert Politic.
Here.
Kevin Kirkwood.
Present.
Thank you. You have a quorum.
Thank you. Do we have a report?
Yes, sir. Good evening, Planning Commissioners. I did have a few reports for you this evening, and I wanted to talk with you a little bit about schedules as we're nearing the end of the year. First of all, and perhaps most excitingly, this Thursday in the afternoon, you all should all have been invited to a joint work session between the Planning Commission, the BOCC, and the Comp Plan Steering Committee. So that will be on future land use. It'll be in this room at 3:30. I know maybe one or more of you aren't available. If you are not able to attend that, if you want to reach out to me, we could certainly schedule something at another time that works for you and go over the same information so that we're sure to get your feedback on that. So. Not really, just because of the way it's set up. It's going to be sort of an interactive team situation. But again, if you can't be there, we're happy to meet with you at another time and get your thoughts on the materials so that you all have a chance to participate. So that'll be the first of more to come. I'm certain we will not come out of there with definitely not any decisions. Hopefully we have some direction and we do make some progress, but we'll see about that. So that should be an exciting afternoon. Beyond that, I wanted to talk with you just a little bit about, we have, after tonight, two regular meetings left in the year for December. The first meeting in December, we do have a land use case scheduled, a rezoning, I believe. And then we have the guest speaker that we've talked about, Mr. Jerry Dahl, who is a land use attorney who works with CML and DOLA and others, and so he will be here to speak about the Planning Commission and best practices and all sorts of things like that, and so that's exciting. And then for the second meeting in December, we don't currently have any land use cases scheduled. I would like to offer to this group that we use that meeting for regulations. a variety of regulations, including the tree preservation ordinance, right, that has come out of this group, including some regulations that have come from the board, and we can talk about those if you would like, including the architectural design standards that this group has talked about, including, I'm going to say corrections, right, but some fixes for notice and some of those things that have come up repeatedly. And so we can just use that entire meeting to go over a variety of those things. Hopefully, some of them would be able to be voted on that night. Others of them are a little bit of a heavier lift and maybe more of discussion only, but making some progress. And then we may even have a third category, which is sort of some brainstorming and some working on some other even bigger conceptual ideas. So we will plan to do that on the, 16th. That would be your regular meeting, your second regular meeting in December, right before the holidays.
I have a question. Do
Yes, ma'am.
things have to be redlined in order for us to vote on them?
I'll defer to Lance.
Yeah, I'll take a stab at that. Generally, the answer would be yes. If you're considering regulatory amendments, you need to know what those amendments are. Otherwise, it's just conceptual. So certainly the Planning Commission could make a conceptual recommendation to the board, but if the board adopted that without more, it wouldn't accomplish anything. So before a regulatory change means anything, it needs to actually be in the form of the regulation with the language that's being proposed and ultimately approved.
Okay. And let me just clarify it too by saying, so if you submit regulation language that you think would be a good idea, or substitute language that you think would be a good idea, maybe even redlining it yourself, with the applicable area, if there's other sections that it will impact, but those aren't redlined as well because maybe they're not known at the time, is that something that we can still move forward with, or do we need to do that comprehensive redline everything in the zoning regs?
Yeah, I don't want to say it could never move forward without catching all of the subsequent changes, but notice ultimately would have to catch all of the subsequent changes. So if, for example, you had a regulation where you were changing a name or a title or something, let's say Board of Adjustment, you were changing from plural to singular, the way the statute reads. Not catching all of those sections wouldn't be catastrophic, but you also couldn't just amend them because they also were incorrect. You would at some point need to properly notice each section that's being amended in order to complete the process. So it's complicated because notice is part of it, the regulatory change itself is part of it, catching everything that's related so everything's consistent is part of it, and preferably that would all be done at the time that things are being considered in the first instance.
Right. Okay, so it sounds like if we're going to vote on anything, they have to already be noticed that's going to be voted on, or at least that it's redlined and ready to be voted on prior to the December 16th meeting.
In order to have proper notice of the meeting, yes, you have to have notice of what you're intending to do. So
Yeah.
if you're considering regulatory changes at a minimum, I would say you need to
Yeah.
reference the sections.
Okay.
And so in line with that exact same sort of train of thought, that was kind of the purpose of kind of mentioning that we would kind of divide it up into sections for this group, right? Some of them may be more discussion, and we'll certainly notice those, but again, understanding that we just likely wouldn't have finalized red lines on some of the really bigger topics. We will certainly bring a starting point, at least for the vast majority of them. So we can see where we get. I mean, if you all just love them and you're like, great, let's vote on these, we can do that. But I don't want to assume that that would be the case for some of the big ones, like the design standards, right? And some of those things that are just, there would probably be a lot of opinions on those. We'll at least bring something to begin the conversations and have those noticed. But does that make sense? Like I said, and if there's other suggestions for that, you can certainly let us know. But we do have, some of them, again, are much easier, and then some of them are more conceptual. Mm-hmm. But we have to start somewhere, right? I believe, let's look at my list here. I believe those were the reports I had for this group.
Fantastic, thank you. We don't have a room full of citizens, so we will bypass citizen comment and move directly to the approval of the meeting minutes. Did everybody have a chance to peruse the meeting minutes from October 21st, 2025? Any suggested changes, comments, concerns? Fantastic. I'll hear a motion.
Oh, I just want to thank Wendy again for doing such a good job with those minutes.
Good comment. Thank you. Can we have a motion to approve the meeting minutes from October 21st, 2025?
I'll move that we approve the minutes.
Second?
Second.
All in favor?
Aye.
All opposed? Looks like 8-0. And with that, we are going to open the public hearing process. This is a process that focuses on the idea that this body will conduct a quasi-judicial hearing, which means the body must find facts and base its decision upon the application of adopted regulation standards, criteria, and the competent, substantial, and material evidence reviewed and received during this meeting. With that being said, let's open the public hearing and staff presentation.
Sure. I will bring up the packet for review, and then your county attorney will be leading the discussion tonight.
Is that it?
Yes.
Commissioners, thank you for your time this evening. You've got a couple different changes in front of you, and I don't really like to come and correct anything, but this is not a quasi-judicial process this evening. Instead, it's quasi-legislative. So you are not bound by the record, you're just bound by what you think the best decision is or ought to be. That's not normally the case. Normally, you're considering an application of some sort where people are presenting facts to you, and you're deciding if the facts meet the approval criteria. For legislative changes, that's not the case. So there's a couple different, one major set of changes brought before you this evening, and one very minor change, but a significant typo that exists in existing regulations. Let me start with the Board of Adjustment. I was recently reviewing the Board of Adjustment for the county, and I realized that there was a number of things in the Elbert County regulations that are simply inconsistent with statute, all in the section of the Board of Adjustment. For example, a Board of Adjustment is supposed to be 3 or 5 members, and the way a Board of Adjustment votes on things is if it's a 3-person board, a decision must be unanimous, and if it's a 5-person board, you must have 4 out of 5 in order to approve something. The regulations said a simple majority, and so I knew that that was wrong, just from experience with Boards of Adjustment. So I started to look at the regs further, and there was a number of ways that the regs, as they existed, were inconsistent with statute. So what's in front of you, while it looks like a lot of red, is really a lot of recitation of the statute that is what the regs should have said in the first place. So I can answer any questions. If you think it's valuable, we can go through each and every one, but I can tell you, you've got the statutes here, you've got the regs there, and much of what you're seeing this evening is verbatim. The one part of the Board of Adjustment regs that's not verbatim is the statute says in your zoning resolution, you can have a procedure for your Board of Adjustment. Boards of County Commissioners are supposed to adopt a procedure, and so I proposed a simple procedure that I believe is consistent with current practice. That way, that element of statute would be completed. I don't know that it ever was before. Finally, the Board of County Commissioners has decided, at least for the time being, that they intend to sit as the Board of Adjustment rather than appoint others. So what the regs would allow is for them to sit, but if they should choose to, they could also name appointments in the future. So it gives them both options, both of which for a 3-person Board of Adjustment. Are there any general questions about what's been proposed or why?
Yeah, let's start with the last part first, right? Okay. So as you're looking at this, does it create a conflict of interest to have the Board of County Commissioners also act as the Board of Adjustment?
I don't believe it does. In fact, it's a fairly common practice throughout the state. I've represented a number of counties, and it's not unusual, and it's not prohibited by statute. So what the Board of Adjustment is, it's a body that sits primarily to review zoning decisions, either decisions made from the chief zoning official, which probably technically is Jennifer, the director of the Department of Community Development. If she were to make an administrative interpretation and that were to be challenged, that's exactly the type of situation that would go to the Board of Adjustment. And there's no conflict in the Board of County Commissioners interpreting that and saying, yes, Ms. Jones interpreted the way we intended, or no, she did not. Ultimately, it's their regs, it's their purview, it's their wheelhouse. There's no conflict in them making that type of administrative determination. Other things that would go to the Board of Adjustment are things like variances. So someone is applying for a variance because their lot is particularly steep or narrow or whatever. They need an adjustment to the setback or some other adjustment that's otherwise in the regs. Again, the Board of County Commissioners is uniquely positioned to make a determination if they think that change is consistent with the overall intent of their regs. There's no conflict in them making those types of determinations.
When was the last time we actually had a separate Board of Adjustments, and how many members were there?
I have no idea. What the regs contemplate right now is a 5-person board, but since I've been with the county, which hasn't been terribly long, the board has been sitting, the Board of County Commissioners has been sitting as the Board of Adjustment. So there is a provision in the current regs that allows them to appoint themselves in the event that they cannot find 5 people to serve in that capacity. But I'm not certain that's the process that's been followed up to now. And it seems to be the desire of the board to actually sit as the Board of Adjustment. So it's probably time to bring the regs in compliance with the practices.
So using that same analogy, and you stated that a 3-person Board of Adjustment has to be unanimous. Have we had an interaction as the Board of County Commissioners standing as the Board of Adjustment here within the last 6 months?
I've been officially with the county since October 6th, at least as an employee. I've been with the county a little longer, but I have personally not sat for a Board of Adjustment hearing. I couldn't tell you the results of any hearing in the last 6 months.
Jennifer, Wendy?
I think we've had maybe one in the last 6 to 9 months, and then we have a couple scheduled for tomorrow, actually.
Okay, so there's a certain amount of expediency that is good to have the 3 people. The question becomes, is it realistic to have, three people always agree on a variance?
I don't know how realistic it is overall. Again, I've served in this role in other counties, and it's not unusual that commissioners agree on an issue. So it might not be as common locally currently, but it's been common in my experience that 3 commissioners can agree when an application is in front of them for something like a variance or for something like an interpretation of their regs, that they don't struggle to get on the same page. It's not always the case, but for whatever reason, in the wisdom of the legislature, they've decided for a 3-person board, it needs to be unanimous. But I'm not sure it's substantially easier if you have a 5-person board and it has to be 4 out of 5. It's still a substantial approval to get to either overturn an administrative decision or to grant a variance.
All good. Do you want to shift over to the procedure, the simple procedure? There may be other questions, but I think the procedure makes sense.
Yeah, and this is all in the same section. What the procedure I outlined was essentially that staff would present the application first, the applicant would get a chance to respond, there would be public testimony. It's the type of procedure you're used to seeing. But because the statute anticipates that would actually be adopted rather than simply followed as what Robert's rules would call a standing rule, I decided I would put it in the regs. So I was not trying to be creative.
Come on, where's your sense of adventure?
Not here.
Any Any questions from the planning commission? Dee Dee, I'm looking at the back of your head. I'm sorry. Okay.
I just had one comment. When I was reviewing it, I noticed that there was a change to, and this is, grammatical, but I noticed there was a change to lowercase, the letter B, if you're just referring to the board. But there were a couple spots, and I don't know if that was intentional or not, but there were a couple spots where it was left capitalized or put in capitalized that I just wanted to bring to your attention.
It is a defined term, so therefore it should be capitalized.
Well, I can show you if it,
No, I believe you.
I believe it was in Article 2, or when it's the first instance of it being lowercase. Maybe it is Article 1. So I wasn't sure what the intent was. When the word board is by itself, I noticed it's capitalized otherwise. Yeah. Is that the Article 1? So if you do wish to lowercase that word when it's by itself, where I found it was in Article 2, Section 13, twice capitalized. That was the only revision I had so that we don't have to revise for consistency purposes in this section again.
No, I thank you for pointing that out. My intent here was, I believe the zoning resolution defines the Board of County Commissioners with a capital B. And so when I was referring to, or trying to refer to, I can't promise I got it perfect, the Board of Adjustment, I was using a lowercase b when I was generically referring to that board. So I will look at all of this again, certainly before it goes to the board. But in general, in the regs, and in this section in particular, I was trying to keep capital B for county commissioners and lower b for Board of Adjustment when I was only using the term board.
Oh, okay, yeah, because I didn't realize that. And obviously, in this case, we're talking about different boards.
Right.
So I appreciated it when you just use the full title, because then it's very clear what board we're talking about. And if that is the rule, I guess that's good to know, because I didn't realize that we only capitalize certain boards versus other boards.
Well, it's not the rule, but if it's defined
zoning
that way, it's to be
regulations.
consistent, yeah.
In our zoning regulations.
Right. So I will look at that again, certainly, and if you want to give a condition of whatever your recommendation may be.
Just so we don't have to update again for consistency
No,
purposes.
thank you, I don't want to update again either.
Yeah.
Any other comments?
Yep, hang on. While you were talking, I was looking through the county website and the resolutions that were passed. So there was a variance that was adopted August 13th, and it was the Board of Adjustment that sat on that. If that's any help, it was Resolution 2537.
No, was there a question or just a comment there?
Just more information into the question to Jen about whether the Board of Adjustment had met in like the last 6 months.
Sounds good, thank you.
Sure.
Any other comments? Do we want to go line by line through this, or do we want, I've read through it, I don't see anything that causes me concern or consternation or...
And if it's about statutory compliance, then,
Yeah, I'm not the guy for that, so.
but I'm saying our attorney is, and if he's saying that this language is important and necessary, is any of it go beyond what is statutorily required besides your procedure suggestions?
No, I tried to use the exact statutory language everywhere I could.
do we want to raise a vote for the change in Board of Adjustment rules and regulations?
So Commissioners, there is one additional change outside of the section for the Board of Adjustment. If you'd like to consider that now and maybe vote on them together, you can. If you'd like to take up this section on its own, you can do that as well.
I was thinking to keep them separate.
Okay?
I guess I do have one more question. Jen, you and I had kind of talked about it, the table of contents. Did that need to be, that's such a small thing, but does that need to be in this red line document?
Not technically, the table of contents, is not really adopted by the board. It's prepared by staff to direct people to where they might need to be. So it's not something that has to be adopted. And so I think we could change that to reflect any other changes if it became appropriate.
Sounds good, thank you.
So I'll entertain a motion to adopt the changes to the Board of Adjustment regulations.
I move that we adopt the changes to the Board of Adjustment regulations.
Do we have a second? And all in favor?
Aye.
Aye.
Any opposed? Thank you. And now for the other regulation change.
Okay, up on the screen, you'll see this paragraph 4. I believe this is in Article 3. Is it? Well, anyway, you will see redlined 3H4 replacing Section 3G4. The reason is the G is a typo and the H is correct. So what is being referenced here is review criteria in another section of the regulations. If you go to subsection G, you actually do not get to approval criteria at all. You get to a section involving concept plans and other issues. So this was always intended to be H. I have no idea, because we've looked, how long this has been in the regs, but it goes back a ways. But this is wrong. This came to my attention because I'm defending a county denial in district court, and it's being pointed out by the other side that we don't have approval criteria at all because of this typo. So this typo needs to be fixed. It's nothing more broad than changing G to H, but it is important.
You know, and I'm sorry, I know we just voted on it, and I realized that there were a couple of places in here where, like the Roman numeral 2 was the 2 ones, and I didn't know if you guys had picked up on that. So if you want, I can, it's only a few. I can tell you what they are now, or I can give them to you afterwards, whatever works.
I'll take them afterwards. That's a font issue, but you
Yeah.
might as well fix it if they're in the same sections that we've already noticed.
Okay.
So any questions on the proposed typo fix?
I do have a question. So if you have a typo and you say, so it's wrong. So there have been decisions in the past that were made with this being incorrect. Is that the way we interpret this? I mean,
Probably, maybe.
or is it pretty irrelevant?
Well, I don't know if it's irrelevant. It needs to be fixed. The reality is, if you have a citation to approval criteria, you want the citation and the approval criteria to match. You want that to be correct. So having identified it now, it does need to be fixed. We want to direct people to approval criteria. We want the regs to be correct on that. We're being challenged on that as a county, and the challenge is that there's no approval criteria at all as long as it reads this way. And therefore, we have no basis to deny any application. I don't necessarily agree with that, but the court's going to tell me the answer. I can't tell you how that's going to play out just yet. But it's not a small issue.
Small typo with ramifications.
Yes, sir.
Okay, so shall we approve the typo fix?
I move that we approve the incorrect citation and fix the typo. in
Second.
Article 3.
And we have a second? Dan, thank you. All in favor?
Aye.
All opposed? Call it done. Thank you.
Thank you.
I'll just add that most of the Roman numeral issues that you brought up, Commissioner, they were actually included in that previous package of corrections and revisions that are still before the board. So a whole bunch of those, we can add these, and then a whole bunch of those would hopefully and theoretically all be corrected.
That was going to be my next question, because we went through a series of regulation changes, including excluding a large percentage of the economic development zone, almost all of the economic development zone.
Yes, sir.
And I know that went to the board for a hearing. I also know that it was not fully agreed upon in that meeting. Where are we at with those?
So they have had, the Board of County Commissioners has had multiple work sessions specifically on the EDZ. They're actually having another one this Thursday. So that has been, that conversation has blossomed significantly. They're currently looking at both the map and the land uses associated with the EDZ. There are a few proposals being discussed at those work sessions, including creating an east and a west EDZ with different land uses allowed. There's discussion of perhaps a central EDZ. I think that one maybe has a little bit less, I'm not sure if that one would go forward or not. The east and west seemed more popular, for lack of a better word. So it's still being discussed. They're looking at the map really more so now, and at the last meeting.
I just noticed that even on moderate transportation zones, there is still a significant number of development sites for sale. And, they're listing, these sections in the middle of nowhere, frankly, as a development zone. And, we've had interesting articles and discussions with landowners relating to building a storage unit in the middle of nowhere. Things like that. And I know that we put a proposal together. I just think that we may have conflated this too much. Is there any other conditions that are occurring that need to be considered? You mentioned a discussion with the state or a lawsuit with the state. Is that part of this EDZ conversation?
The lawsuit I was referencing, it is a land use challenge in the district court here in Kiowa. So it's the Peak Vista RV storage facility. It was an application for a site plan under the economic development regulations, and that was denied by the commissioners 2-1. So we are in a Rule 106 appeal of that decision, where the applicant is arguing that they should have in fact been approved. So different in kind from what we're talking about the greater regs, but this typo came into play for that specific litigation and defense of the county's decision.
Got it. And I will ask my other questions off the channel. So, any other elements that we need to be discussing tonight relating to regulations?
Yes, I have a question about my favorite topic, tree preservation.
Yes, sir.
So I've raised this issue for some time, as you know, and there was a presumption we did not have a regulation, and therefore you encouraged me to, spend some time, draft a regulation, and submit it. And, I used Nicole's assistant to do that. And so in a recent hearing, there was a reference by Danny to the fact that there was, in fact, a tree regulation, which was a surprise to a lot of us. And one of the questions I asked,
Who's Danny, Dan?
Pardon me?
Who was Danny?
This is
Danny the
planner, the
planner.
staff planner.
Yeah.
Okay, thank you.
Yeah, our Danny, not this Danny. And so, it was pretty easy to presume that that's fallen through the cracks, and it has not been applied. So I have some real questions about that. So now, as I understand it, we are going to take a look at this regulation that Nicole and I drafted. But to me, this is a big deal that we had lost. I mean, it's likely that there have been approvals that could have been affected by enforcement of that regulation. The best example I can give you, it's not approved, is Miller Ranch. Miller Ranch, as it was proposed originally, were 2.5 to 5 acres. And there's a large forest on that property, and the majority of that property is going to be preserved. Now, under the new, and I know it's changed, but originally they proposed 1,400 homes. And I don't know how many dozens of acres of trees, mature trees there are there, but, they were all missing in this, original schematic. And one would think that would have been one of the first things the planning department would have done with this potential developer, is to say, wait a minute, we have a large forest here, we have a tree regulation, and this is what it states. So,
Is there any additional conversations going on with the Miller Ranch subdivision?
Yes, sir, it's an active application.
Okay. I think we do need to table the conversation because we're on the edge of talking about something that, with respect to the Miller Ranch piece of it, that gets us in trouble. But we do need to consider the deforestation effect and the fact that we don't have a tree plan.
that is one thing that can get you in trouble in both ways. So,
We can speak generally if you would like. Sure.
I just think it's important that we understand, what happened, how do we learn from that, and make sure that, I asked Danny if he'd be good enough to compare the two, because I couldn't find the regulation. And I was up, Mike Buck and I were looking at it, he couldn't find it either, the existing regulation.
But I've sent it to you, right, since then?
You sent me the old regulation, but I was looking for kind of a comparison.
Oh, okay. Sure. So, I mean, we can certainly discuss a comparison or a change, right? So there is some simple language. I know when you and I had discussed this sort of early on, right, we had talked about that you felt that it needed to be, this would be a fairly robust language, right? Not a sentence or two, right, but something more robust. So that's certainly, something extremely robust certainly doesn't exist. There is some language that could be, there is some language, I'll just say that. There's some language. And so that is being reviewed. So along with, right, all of the regulations. So I'm not sure, again, nothing has been finalized on any hypothetical
And
projects.
hypothetically, is it timely to be considering this tree plan or in December? Does it meet the timeline to protect forested zones hypothetically in the area?
Sure.
I think it's
so.
only fair to the developer that they be aware of this, because
Sure.
it's a dramatic change.
And it has been brought up numerous times.
Okay.
Absolutely, for sure.
Using the existing regulation.
using the general concept of tree preservation has come up repeatedly from appointed and elected officials. So
Well,
even in conversation like that,
using the term general concept is one thing. When you have a tree regulation that spells out specifically, when you're removing trees, you have to, replace them with too mature trees, things like that. That has pretty significant repercussions for a development
of course.
as they proposed. So,
And just while we're on the topic, for clarity's sake, so under the old regulation, there's about 5 sentences that apply to trees and forests and things like that.
Open space, I think.
No, this one is about forested areas. But the question I think would be better for Lance is if an application comes in, it still is going to be processed under the regulations that it was introduced into, correct? Like if we amend the regulations to add a very, detailed tree preservation policy regulation, existing applications that are already in the pipeline would still be under the former zoning regulations. Is that correct, or is there a point in which we could say they're going to apply, the new regulations apply?
You're going to love this. It depends. So for subdivision applications under
Wait, so
Colorado
did you say your
law-
occupation was lawyer?
For subdivision applications under Colorado law, it is absolutely black and white. The regulations that are in effect at the time of the application will control. There's no discretion, there's no debate. It's black and white. For zoning, it is not so clear. Zoning does not have that language in statute, and I don't believe we have it in our regs. And there's a legal principle out there called the pending ordinance doctrine, which could allow the application of an ordinance that is pending but not yet adopted to be applied to a pending application. Now, I believe that's a decision ultimately that would be made by the Board of County Commissioners if something was pending and they still wanted it applied, but it depends on what you're dealing with, whether there is a legal basis for applying a change.
And I want to clarify on the existing regulations and reviews, in particular of large-scale zoning projects, right, or a large PUD or something like that, that again, at the time of zoning, we don't, again, I was using terms like general concepts because we provide that guidance. Yes, that regulation is in there 100%, but until we're doing an actual final plat or something like that, we're not necessarily going to know the details of, right, where a building envelope is going to be on a lot, right, or things like that. So there could be significant preservation despite a certain amount of acres being zoned. Does that make sense? So that's not, I just want to clarify that, right? A zoning doesn't necessarily mean that all the trees would be taken out. And so we always get more specific, right, with the next steps, or at time of preliminary plat or final plat. That's where we're really going to be looking at, right, where those building envelopes are, or where the exact location of the roadways or the lots or the open space. And so just clarifying that piece of it in terms of specificity.
And just to add on to that, if we don't have something that we can hang our hat on until final plat for a PUD, and you've got an applicant that spent years maybe to get to that point and a lot of money, and it gets to the final plat, and we look at it and say, well, there's a stand of trees here, and we don't want you to cut them down, but they've already gone far enough that that wasn't an issue before. Does that make sense? That it's kind of late in the game, I would think, at that point, to try and apply a tree plan.
and see, that's part of my point. It's got to be fair to the developer. They spent significant money purchasing this property under the assumption that they were going to increase the density substantially by removing a lot of trees. Now, they should have read the regulations, or they should have researched the regulations, technically, before they purchased the property. They should have really done their homework, but it fell through our cracks. So it's one of those things that if we didn't see it, maybe it wasn't transparent.
I guess I don't know that it fell through or that it has been missed. Again, nothing has been hypothetically approved.
Yes, you know, I'm interested in that for all the right reasons, or for personal reasons that I'll likely recuse myself when it comes to, this commission. I would, consult with you regarding that. But, this is a serious, situation given the gravity of this change that they're seeking, compared to what has previously been approved, as the original Mill Ranch plot. So I just think we need to get more information and have a better understanding of what happened and what is required as a result of what's happened.
If I could make a suggestion too, I find it hard to have these conversations when I don't have like the regulations in front of me or something that I can look at and have an informed conversation. Could we carry this, at one of our December meetings and have a good, robust discussion about it with just us?
I think that's the general principle of where we're going. We're having the meeting in December. The second meeting in December, we'll discuss the tree regulations and deforestation elements.
Yes.
And it'll be timely still, which is why I asked the question about timeliness.
Yes.
And so I can't wait for that session. I think it's a good conversation. I think it's a good thing to be considered. But I think we've reached a point where we need to wait and see what's happening inside the regulation itself. I personally haven't read what y'all put together yet, but I will. It's brilliant. I'm sure it is. Any other comments, questions, concerns? This is time to stump the lawyer. Any other comments, questions?
I was just going to say, I have a couple of other suggestions for adding to the meeting in December, so is it okay if I email you with those? For
Sooner the better.
regulations? Sooner the better.
Yes.
Okay.
And
Any other topics to consider tonight?
I have a question for Lance. And Jen and I had been talking about the notification process for the zoning regulations coming in front of the BOCC and the need for that to be a 30-day notice per the regulations. And I had asked Jen about that because back in April, we had that work session with you and Mark, and that discussion had come up because Kevin was saying, how fast can we get these regulations in front of the board, and do we, how does that 30-day fit in? Do you have to wait till we make a decision? So can you speak to that, and can we get something on the record so we never have to talk about this again?
I don't think there's any topic an attorney can weigh in on that won't necessarily come up again, but I appreciate the opportunity to put this to bed. The regulations do not say anything about before, after, et cetera. They say 30 days. So before the Board of County Commissioners considers regulatory changes to zoning, there must be published notice at least 30 days in advance. That's all the regulations require.
There's a lot of latitude, so that notice could go out 3 weeks before, say, a planning commission hearing, and then the BOCC maybe would hear it a week after us, rather than that long.
As long as it's at least 30 days before the BOCC, that's
Okay.
what the regs require.
Perfect, thank you.
Interesting point. Any other comments, any other pieces of topic that we need to discuss tonight? Then I will entertain a motion to adjourn.
And I will, I motion, I make a motion to adjourn. Thank you.
Just a second, please.
Second.
All in favor?
Aye.
Thank you very much.